lawyer, fire me as a client? The short answer is yes. Under certain circumstances, your lawyer can withdraw their representation of you, essentially firing you as a client. The engagement letter you signed prior to commencement of representation might set out some of the circumstances in which you agree that your lawyer is permitted to withdraw, and the state might have additional professional and ethical rules that govern the issue. But here are a few reasons why your lawyer could potentially terminate representation. As usual, I'm really just speaking about corporate and transactional attorneys, as litigators are often subject to some additional and unique constraints. Non-payment of fees. Your lawyer can't fire you as a client if you are a day late on your payments. But if you fail to pay your bills and you aren't cooperating to find an amicable resolution, you should not expect your lawyer to continue to work for free. Illegal conduct. If you plan to engage in illegal activities despite your attorney's warnings, your attorney may be permitted or even required to withdraw their representation so they aren't deemed complicit in your illegal behavior. Misconduct against the attorney. This could be anything from trying to defraud the attorney to abusing the lawyer or her staff with inappropriate racial or sexual remarks or threats. If you undermine the relationship of trust with your misconduct, the lawyer is not required to continue to represent you. Conflicts of interest. We'll talk about conflicts of interest in more detail in future videos, but the idea is that if an irreconcilable conflict arises between you and another of the attorney's clients, and that would prevent the attorney from being able to represent both of your interests effectively, the attorney will be required to withdraw entirely. Your engagement letter might contain some language specifying some potential scenarios, particularly if it is a joint representation or if the attorney believes that there's some possibility of a future conflict. Inability to provide effective counsel. This could be because you are refusing to cooperate with the attorney or to provide the information and documents that your lawyer needs to effectively handle the matter. Or it could be because you're requesting that the attorney handle items outside of the original scope of representation, and the attorney knows that she doesn't have the requisite experience to properly handle them. Regardless of the reason your attorney withdraws, they still have certain ethical obligations toward you, which we can discuss in a future video. But they shouldn't just disappear into the ether. They need to communicate with you and appropriately transition you to new counsel. Business owners. Are any of the grounds I mentioned surprising to you? Have you heard of other reasons that I omitted? Share your thoughts in the comments, but remember that anyone can read them, so don't write anything private or confidential.